Welcome to the Lawyering Peace interview series, where we explore the intricacies of negotiations, accountability, law, and diplomacy in peace processes. Join us as we dive into discussions with individuals who have played key roles as diplomats, lawyers, prosecutors, defense counsel in negotiating peace and justice. I'm your host, Dr. Paul Williams, the founder and president of the Public International Law and Policy Group, and the Rebecca Grazier Professor of Law and International Relations at American University. In this interview, I am joined by renowned international criminal defense attorney, Kate Gibson. Kate is also a senior peace fellow with the Public International Law and Policy Group. Kate, welcome to the program and thank you for joining us.
Thanks very much, Paul, and thank you for having me.
Now, Kate has been appearing before international criminal courts and tribunals since 2005. She represents former heads of state, military leaders, as well as victims of atrocity crimes in some of the leading cases in the field. Her former clients include the former vice president of the Congo, Jean-Pierre Bemba, Congolese militia leader Bosco Ntaganda, former Liberian president Charles Taylor, former self-declared president Radovan Karadzic, and former Rwandan minister Justin Mugenzi. Kate is currently on the legal team for the former president of Kosovo, Hashim Thaçi. Kate is also a dedicated supporter of the rights of the Rohingya people, and in 2018 was appointed as a legal consultant to the Independent International Fact-Finding Mission on Myanmar. Kate currently represents a group of Rohingya victims in Cox's Bazar, Bangladesh, and I can say from extensive personal experience that she has been an integral member of PILPG's team working with a group of Rohingya documenters in Cox's Bazar refugee camps over the past 4 years. Now, in today's conversation, we will draw upon Kate's extensive experience before domestic, international, and hybrid tribunals, and her perception of the role that accountability plays in securing a durable peace. Well, Kate, let's kick this off. We've just seen that you've been engaged in so many of the most high-profile tribunals and investigative mechanisms over the past 2 decades. Let's start with, what is your overall assessment of whether and how those tribunals contribute to a durable peace?
Thanks very much, Paul. And I like that we're starting with a big question right off the bat. Do international criminal trials contribute to a durable peace? I think this is something that's often said. This is often put forward as one of the main drivers of international criminal trials, that there's no peace without justice. Holding these people who committed or ordered or planned these crimes to account is certainly a way of reinforcing a long-term durable peace that we need to see after a situation of mass atrocity or conflict. We can't just have perpetrators continuing to hold their positions of power or even just continuing to live their lives in the community. Victims need to see some form of accountability in order to be able to move forward. And that makes a lot of sense. Criminal trials can play a role in sustaining peace and ensuring non-repetition, and also reinstating respect for the rule of law in a society. And so, as practitioners of international criminal law, we often congratulate ourselves on the fact that our work contributes to peace. And as a basic premise, I think that's right. But the reality is a lot more nuanced. Criminal trials can only contribute in this way when they're viewed by the affected populations as being legitimate, as being an inclusive process that isn't one-sided, that isn't prosecuting the wrong people or only a small group of people. And that's where the difficulty lies, because we see often after a situation of conflict that prosecutions are often one-sided. You have the victors prosecuting the vanquished. And so it's not a big leap for one-sided or politically motivated trials to move from contributing to peace to doing the exact opposite, to reinforcing the lines of division that were there before. So I think criminal trials have the potential to contribute to a durable peace, and I doubt that sort of peace is possible without some kind of accountability. But I think before we can sort of pronounce that as a universal truth, we need to talk to the populations of these situations of conflict and find out whether or not they think it's the case. What does the population in Rwanda or Cambodia or the population of Ituri in the Congo, who were the apparent beneficiaries of these first ICC trials, what do they think? You know, do we see durable peace in post-conflict states? And if so, do the victims see the criminal trials as having contributed to that? And I imagine that the answers are really going to differ depending on the situations and depending on the quality of the justice that was delivered and of the independence of the justice that was delivered.
Well, Kate, I'm glad you mentioned that, because honestly, I'm one of those people who declares no peace without justice. It's a universal pronouncement that is certainly true, but I don't actually know if that's the case. And so one of the reasons for having this podcast series is actually to literally virtually hang out with some of my close friends and find out what the true answer is to that. So let me pick up on that a little bit. Ideally, well, let's say clearly we're having an increased dimension of justice in peace processes. We're having indictments now, not only after a peace negotiation, but sometimes during a peace negotiation and even before a peace negotiation of individuals who previously would have been considered partners in peace, or at least necessary to get to an agreement. Hopefully the mechanisms of justice are more fair and more balanced and hopefully more competent. This arc of increased accountability, is this going to help or hinder? Are we at the sweet spot, the Goldilocks spot right now? We should just kind of keep here with let's say maybe a 300-pound adolescent gorilla, or, you know, should we be cross-training the gorilla and making it stronger and stronger so that it can more directly and more impactfully influence these peace processes? What are your thoughts on that?
Well, I mean, I think I'd start by looking at whether there is this increasing arc of accountability. You know, because an argument could also be made that the trend is moving in the other direction. I know that's not true for Ukraine, for example. After the Russian invasion, we saw this robust response from states calling for criminal accountability, calling for investigations, calling for trials. But on the other hand, we have sort of a growing skepticism, I think, of some states who want to move away from wanting to fund what they see as these incredibly expensive international proceedings. And if you look at the ICC, for example, which is where I do a lot of my work, it's supposed to be this pinnacle of international criminal accountability, and it has nowhere near universal support. We have 124 states parties, but the exceptions, you know, US, China, Russia, Israel, even Ukraine isn't a state party. These are huge gaps. We don't yet have universal support for the court. And we see that every year when we have this funding to try and get this battle to try and get funding from states parties. And we can see that there haven't been new ad hoc tribunals being established. States really seem to have a preference for funding investigative mechanisms in Geneva. You know, there's no tribunal for Syria, there's no tribunal for Myanmar, there's no tribunal for Iran. Instead, we have these fact-finding missions, COIs, investigative mechanisms to support primarily domestic prosecutions of international crimes, which would be great and which would move us to this sweet spot, which was where I think we need to be. But then we have the problem that states that do have universal jurisdiction to be able to prosecute these sorts of cases domestically often don't have the resources within their domestic prosecution offices to be able to redirect it towards complex international criminal cases, which are, you know, objectively incredibly difficult to build and present. And also then in post-conflict states, you often see that the judiciary is decimated and can't easily rebuild without outside support. So I don't know if we've yet hit this mecca of international criminal accountability that it looked like we were building towards in the early 2000s. And I think any peace process can't automatically assume that there will be support for a parallel criminal justice process. I think in an ideal world, it would be there and should be there, and they would be feeding into each other. And we certainly see examples of that happening. There would be more, indictments, arrests, and more justice as part of this peace process. But I think it really depends on whether states see it as being in their interests to have that parallel justice process.
Well, Kate, I love where this conversation is heading, because you have such a balanced perspective on the need for, but also the limits of justice and accountability. So let me ask you a really simple question in line with this balanced perspective you have. Is it ever a good idea to trade amnesty for peace in a negotiation?
That is not a simple question, but it's a very good question, because this is the flip side of your peace versus justice pronouncement. What if peace is put on the table if justice is taken off the table? What if you have a party to an armed conflict who's willing to lay down their arms if they get guarantees of non-prosecution? What if the insistence on having criminal trials is an obstacle to immediate peace? And we've seen this, right? We've seen situations in history where killings have been able to stop if justice has been pushed further back in the list of priorities. So your question is this appropriate or effective to trade amnesties for peace? I mean, there's a legal answer, and I can cite to the decisions of the various international courts and tribunals for Sierra Leone, for the former Yugoslavia, where we see international judges saying, amnesties for these core international crimes will be invalid. You can't legally give someone who's committing genocide a guarantee of non-prosecution. And this lines up with the obligations of states who, for example, will have an obligation as a signatory of the Genocide Convention of 1948 to prevent or punish genocide, or a signatory to the Geneva Conventions who has an obligation to punish people committing grave breaches. So there's a real risk that if amnesties are granted, particularly for core crimes, they won't be valid under international law. But, as always, I think it's really important to be guided by what does the affected population want? What do the civilians who are the target of these crimes saying? Do they care at all about the prospect of an international trial in The Hague if it means that the violence stops and their children are safe? These are interesting legal questions, but the human cost and perspective has to be taken into account. It's fine for me to say, this would set a terrible precedent to trade amnesties for peace, or, this kind of amnesty is invalid. But I think it's our job as people who work in this space to try and connect with and understand and give primacy to the views of people who are the ones that are affected by these crimes.
Well, Kate, let's walk through that a little bit, because one of the arguments for accountability is that it creates a historical record. So if you grant amnesty, you'll never have accountability. If you don't have accountability, you'll never have an accurate historical record. And we all know that, revisionist history is part of sowing the seeds of the next conflict. Those of us in the justice first camp, meaning me and some of my colleagues, are we overselling this notion of tribunals create accurate historical records?
No. I think that's something that the tribunals actually do very well. Without these tribunals for Rwanda, the former Yugoslavia, Cambodia, Sierra Leone, the factual records of these conflicts would be less complete. That's clear. The judgments from these courts are a very important historical record. The evidence uncovered, the testimony from direct witnesses, the evidence being tested by experienced courtroom advocates, the preservation of the physical evidence, the archives. I think this is something that the tribunals can legitimately congratulate themselves on. But I feel like there's a but for every one of my answers. But I think the historical record is only as complete as the process allows it to be. If we have one-sided criminal trials, so we're only punishing perpetrators from one side of a conflict when crimes were happening on both sides, then we're going to have a one-sided record. You know, if states want to try to limit their support for criminal justice to only those conflicts that are uncontroversial or where their own interests aren't at play, then the historical record will reflect that. And so you have the same risks that one party to a conflict will say that this record that you've created, it's distorted, it's reinforcing divisions along the same lines that were there before. So this can be a double-edged sword, and it really reinforces the need for criminal accountability to be impartial and non-selective and as universal as it possibly can.
Okay, let's continue down that path, because one of the other things that we like to tell ourselves is tribunals are a crucial part of victim catharsis. They provide a process for victim catharsis, and this victim catharsis promotes a durable peace. Now, you've represented and worked on behalf of victims around the globe. What are your thoughts?
Yes, I really agree with this. I think if victims feel that they have received some kind of closure, some kind of accountability, and even reparations that help them process the crimes that were committed against them, then that is the absolute ideal. That's what we're aiming for. And I think that can promote forgiveness and reconciliation and peace. Whether or not they feel that way, I think is something that we as a legal community could do a much better job at tracking. We have a tendency to sort of finish these trials and convict or acquit the perpetrators and then, close the brief and move on to the next one. What I think would be really useful and most interesting would be to go and speak to the victims of conflict where there has been a criminal trial and see what they feel like at the end of it. My experience is interacting with victim communities in Rwanda, in the Congo, for example. I know that there are groups of victims in these situations who feel extremely let down by the fact that the crimes that their families and loved ones were subjected to didn't form part of the investigations or the trials that happened internationally. And we can see that in the very, very small number of situations where the ICC or the tribunals have been enabled to investigate, to issue arrest warrants, and then take suspects into custody, that's a tiny, tiny fraction of the number of perpetrators in these sorts of situations that we're talking about. And we also know that reparations processes, where they do exist, have been extremely slow and very selective and really difficult to administer. I'm still litigating reparations in the Ntaganda case at the ICC, and my client Bosco Ntaganda was convicted in July 2019. So we're 5 years on and the reparations process still isn't settled. So I don't think it's possible to talk in sweeping terms about, tribunals provide catharsis for victims, full stop. I would love to think that the trials that I've worked on have given some measure of catharsis and healing to those communities. But, that's our job. That should be our next challenge, to try and find that out from the victims' communities themselves and then build on what worked for them and try and correct anything that didn't.
Okay, let me take it to even a broader perspective. So we've talked about historical record, victim catharsis. There are now arguments being made by friends in our community who say, well, tribunals are essential for promoting reconciliation and rebuilding or restitching together social cohesion. One, is that true? And two, are we asking too much of tribunals now, moving from trying those accused of atrocity crimes and deciding whether they should be put in jail or not, to historical record, victim catharsis, and now social cohesion. Or it's hugely valuable, and we should be doubling down on its role in promoting social cohesion and reconciliation.
Yeah, I think it's fine to ask too much of tribunals. I think we should be asking for as much as we can from these processes that do get the direction of so many of the resources that are directed towards a post-conflict state are often given to these criminal trials. So it's important that they do deliver these things, or at least have the ability or the hope of delivering these things. It is another stated aim of the ICC and the tribunals that through genuine criminal accountability, a society that's emerging from a situation of mass atrocity will be able to reach genuine reconciliation through the process of these criminal trials. I'm not sure we have a clear example of this yet, or a good example. I'm not sure we can say, all right, this is a clean, teachable, here we had a conflict, then we had criminal trials, and now the society is reconciled and healed. I think we know that reconciliation of devastated and decimated communities is never fast, and sometimes it's generational. I think we can say that if there is impunity and no accountability, reconciliation will be much less likely. So I think in this way, we can say the tribunals contribute to the healing of societies and allowing them to move forward together. But there are many other factors at play, perhaps most importantly being the support of the international community, and also a sort of will on the part of the affected community itself to try to break these cycles of violence.
Kate, is one of the ways of breaking those cycles of violence deterring future atrocity crimes in that state and or globally or regionally? Is there a deterrent effect for these prosecutions? Do people see these tribunals and say, maybe I won't commit atrocity crimes. I don't want to end up publicly tried and incarcerated, possibly?
This one, I think, is more of an uphill battle. We're speaking, Paul, in June 2024. As we're having this conversation, conflicts raging, in Gaza, in Sudan, in the Congo, in Ukraine. It becomes more difficult to sort of cling to this idea that, right, we have an international legal framework, we have red lines that have been drawn by international law. Once they're crossed, there will be no impunity and there will be prosecutions. We see that isn't happening. We see that the application of this framework, which we consider to be these fundamental human rights, is being selectively applied. It's protecting some people, it's not protecting other people. And so I think the deterrence value becomes less and less. And I'm not sure it's realistic to think that the type of military and civilian leaders who are committing crimes against humanity and war crimes today in 2024 are motivated in any way by avoiding a risk of criminal prosecution. I think I've spent more time than the average person interacting with people accused of international crimes or having been convicted of international crimes. And in my experience, they're more likely to see their actions as having been somehow righteous or justified, rather than something that they did outside the bounds of international law that they might later be punished for, right? And they're often supported by communities who feel the same way. I don't think that's a reason to give up on it, to give up on the International Criminal Justice Project, or give up on the idea that it could be a deterrence factor. I think a lot of us who practice ICL do so because we think that international criminal accountability is one of the few tools that's available to us as lawyers to try and combat the horror of conflict and persecution. And it's our role to sort of keep this hope alive. And I think the more that we see heads of state and civilian and military leaders being brought into courtrooms and held to account, the more likely it is that other perpetrators might stop and think, well, that could be me. I'm not sure they do. In my experience, they don't, but I think the idea is still a good one.
So, Kate, when your phone rings, or if your phone rings, and there's a diplomat, a mediator on the other end of the phone, and she says, Kate, I'm about to go in and mediate this conflict between these warring parties. There's been atrocity crimes committed by one or more of the parties. What advice do you have for me, the mediator, to sort this issue during the negotiations?
I mean, that's the million-dollar question, isn't it? What role should this idea of prosecution or non-prosecution play into a peace negotiation? You know, I don't think it's dodging the question to say this is going to be very situation specific. I think we can see from our immediate history that the threat of prosecution did play a role in what ended eventually the Balkans War. I think that the threat of international justice can hang as a huge stick. I think that the offer of non-prosecution, where we're not talking about international crimes, where we're talking about lower level atrocities, can act as a huge carrot. So I think my advice would be not to discount this as an option, to put this idea of justice in the mix in a peace negotiation, and ensure in doing so that neither party who's coming to the table feels like they will be unfairly or selectively targeted because of these criminal justice processes. I think the least selective and more universal the application of criminal justice, the more likely it is to contribute to peace.
Now, Kate, the next question that the mediator is going to ask you is, she's going to say, well, I understand that these international tribunals are independent and that they jealously protect their independence. When I'm in the negotiation and we're talking about peacekeeping, I can work with the UN or NATO or African Union or whomever to have it armed, unarmed, rules of engagements. I can adjust, if it's economic sanctions, more economic sanctions, less economic sanctions. Basically, as a mediator, I can influence any of the various dimensions of the peace process. But then I come over here and there's justice, which you've just convinced me I should weave into my peace process. But I understand it's independent. How is that going to impact my ability as a mediator? And what recommendations do you have for me to interact with this independent body?
I mean, that's got to be the biggest selling point to the parties, that it is independent, because they will see that as a guarantee, as a reason why they should trust that process. We see in conflict situations that potential perpetrators have been more willing to put down their arms and turn themselves in, where they see that justice is a fait accompli, if there is an international and independent aspect to the justice they'll be facing. I mean, the last thing that is going to be helpful in one of these situations is where your former adversary, or the person who's just beat you in a conflict or an election or in any kind of front of, then creates the tribunal and tries one side of the conflict. So I think the independence would be something that the negotiator would have to embrace and sell, because that is the reality, that is one of the main benefits of impartial and independent justice, that it is justice being taken out of the framework of the state itself.
Okay. So embrace it, since you're not going to be able to modify or change. The first, in my work, the first thing the mediator is, okay, right. So how do we influence this mechanism? No, that's a bad place to start from. But you're saying, hey, not only should you acknowledge its independence, but you should embrace its independence as a selling point for the parties. Okay. Well, let me ask you this question. You've been around for 20 years of the last 30 years of this evolving arc of justice. How do you assess this evolution? You've touched on this a little bit, but I want to ask you that question to tee you up for the second part of the question is, where do you see international criminal accountability efforts going in the next 30 years?
Well, I think today in 2024, we've landed on the idea that international criminal accountability is an important piece of this overall picture of conflict resolution. It's not by any means a magic wand. I think we probably have oversold the ability of international criminal justice to deter perpetrators and heal societies. But I think we can say, at the very least, accountability has the potential to, and often does, contribute to peace. But there's also, a growing recognition in the literature around international criminal justice, this emerging idea that this field of ICL, in putting on these very expensive and high-profile trials, has risks and disadvantages. Where we have a disproportionate emphasis on criminalization of conduct, when only a very select small number of perpetrators will be prosecuted, the downside to this is that other non-criminal violations are given a lot less attention, and we have less resources to then dedicate back towards looking at what caused the conflict in the first place. And that's before you even start to unpack all these criticisms of ICL as really reinforcing North-South dynamics, or being, a neo-colonial approach to European solutions for problems of the global South, which are criticisms that are important to voice, and in my view, they're valid ones. And I really hope over the next 30 years, the practice of international criminal law shifts to try and take some of these criticisms into account. And also that we see a regionalization of criminal justice that prioritizes the views and the concerns of the affected communities, over our obsession of the last 30 years, which has been bringing everyone up to The Hague, bringing perpetrators and victims and witnesses up to Europe. And I think my experience has really led me to the view that the greater the involvement and ownership of a post-conflict community can have over the justice process, the more likely it is that they view this as being credible and having meaning to their community. And that's the whole ball game. That's what we're really trying to achieve here. We're trying to find meaning and healing through accountability, so there's a chance at a peaceful future.
Well, Kate, you've been practicing international criminal law for 2 decades. You've been at the center of so many high-profile tribunals, and you've thought about this clearly from our conversation today. Just do me the simple favor of distilling all of that into one takeaway that you want our listeners to know and to remember about the relationship between accountability and durable peace.
Okay, I'll try. Maybe a few key takeaways.
Sure, why not?
These are conversations between lawyers.
You're clearly an advocate. You're clearly an advocate here.
Exactly.
My one takeaway has 4 parts.
Yeah. Part 1. No, I think I agree that we should continue to advocate for peace with justice. I agree with you on that. I'm not sure it happens, but I think it should. Criminal trials, when they're viewed by the victim populations as being legitimate and credible, they can contribute to promoting a durable peace. So I think, your community of peacemakers has the right idea. But essentially, these are all afterthoughts. The more time and resources we can spend on addressing the root causes of the conflicts, the closer we get to the ideal, which is a world in which we don't need any of this anymore, and you and I are both out of jobs. So I think it's worth thinking about how we can try and redirect resources towards looking at the underlying structural problems that are causing these sort of conflicts to happen. That's unrealistic, it's naive, I think it's still worth saying, but at its core, I think international criminal justice or criminal justice processes will be part of any building of a durable peace after a situation of mass atrocity.
So we still have jobs for a little while longer.
For a while.
For a
Yeah.
while. Well, Kate, I wanted to thank you for taking the time with me and with our listeners. It's been a real honor and privilege to hear your insights into the relationship between atrocity crime, prosecution and defense, and building a durable peace. Over a decade ago, my phone rang and Mike Scharf said, "Paul, you've got to meet Kate Gibson. You've got to find ways of working with Kate Gibson on international atrocity crime issues." I said, "Mike, why?" And he said, "Well, two reasons why. One, she is wicked smart. And two," he said, "look, by all accounts, she is the leading international criminal defense attorney of her generation." And I think our conversation over these last 40 minutes, as our listeners can attest to, has really affirmed how wicked smart you are, and why you have the reputation of being the leading criminal defense attorney among your generation. So it is a real privilege to have had this conversation with you and literally to work with you on a daily basis on the various PLPG projects around the globe relating to atrocity crime, prosecution, and defense. So thank you, Kate.
Thanks very much, Paul. It's been really fun to flesh out some of these ideas with you. Thanks for having me.